All right, good afternoon, everybody. Andrew Schaefer here. I'm calling in today from Trafalgar's Pretoria branch. Welcome, and thank you very much for everybody who's attending. Let me put on my video as well. Right, so I'd like to welcome my colleagues today who are attending with me. We've got Caretakers, who is calling in from our Cape Town branch. Karine is our sectional title consultant, property management consultant with more than 20 years experience, and our standard panelist on our weekly training webinars. Karine will be covering the relevant legalities to consider in terms of conduct rules, which is our topic today. We then have Hillian Thompson joining us today as a panelist. Hillian is the manager of our Pretoria branch's sectional title department, and Hillian will be talking us through a case study on enforcing the conduct rules. And then finally, Gillian Hendricks, who's a senior portfolio manager located in Trafalgar's Johannesburg branch. And Gillian also has a case study to present today as an example and for reinforcement purposes. Before we get going with the topic for today, today is the fifth module, the fifth of 9 modules in the training series. So we're now more than halfway. And once again, a very, very important topic today, because I think that the effective enforcement of conduct rules, if they are well defined, if they are enforced consistently, it adds a lot of value to residents living in sectional title schemes, because it does create a harmonious living environment, which is predictable, which is matched to the circumstances of the property, and it goes a very long way for residents living in a collegial and positive way together, and it ultimately adds value to the properties and to people's enjoyment living in the complex. So really, really important that we understand the legalities of how conduct rules are updated, how they're approved, how they're enforced, what the mechanism for enforcing the conduct rules are, how it's escalated and escalated outside the complex to CSOS. And I think if caretakers are well informed and well equipped to understand those mechanisms and the escalations, it gives them a lot of confidence and a lot of comfort in terms of the way that it should be done. Very often caretakers are the first responders because they are working on site. They are known to most residents. They're often called into conduct rule issues and conduct rule disputes. And I think, therefore, if caretakers are well trained on this topic, I think it goes a very long way to the conduct rules being more quickly enforced, more effectively enforced, more decisively enforced, and better consistency surrounding that. I also know that many trustees rely on caretakers to play an active role, and because they're first responders, it certainly goes a long way to make the lives of trustees that much easier, which again emphasizes the importance of this topic and the roles which caretakers play. So I do think this is one of the key topics that we're going to be presenting in this series. And in fact, it was this topic that we started with when we started our client webinar series for trustees and directors a number of months ago. So most of Trafalgar's trustees, or many of Trafalgar's trustees, have already participated in a comparable training topic. Just a heads up for next week, the topic is CSOS, the Community Scheme Ombud Service, which is important to understand its role, how it's funded, what our reporting as managing agents and body corporates is to CSOS, and the role that they play in terms of, first of all, mediating, and then, if necessary, adjudicating disputes. And I think we'll give some case studies in terms of how to lodge a dispute, how the dispute is handled at CSOS, what paperwork is typically presented, how the findings and rulings are made, and then how that dispute mechanism channel can be well utilized where required by residents and trustees of body corporate. So CSOS is next week's topic on Tuesday, and the one after that is another important one on financial management, where we'll look at the way that creditor invoices should be processed and approved. We'll look at the financial reporting, the management reporting to trustees, the audit file preparation, the audit that happens every year, and just to make sure that as caretakers and stakeholders in the management of body corporates, that we all au fait with the important considerations for financial management and financial management best practices. Just lastly, by way of introduction, just a reminder that anyone's welcome to join these training webinars at any time. We do send out the invitation every week with the registration link. You're very welcome to forward these invitations to anyone you think might have interest. You don't need to be a Trafalgar client necessarily. We do load the recordings onto YouTube, and we gladly circulate the training slides, as many of you have asked for before. So that's an open offer to anyone to join. Also to say that anyone that started late, that wasn't able to join from the beginning, we will be making a plan at the end of the series to circulate the recordings, and we can actually track who watches each recording to issue a certificate to those that would like to get training certificates from Trafalgar, having then participated in all 9 training modules. So really it is possible to fully complete the training even if you started late, and if you would like a certificate, that can be arranged and you can get in touch with us at the end of the training series. But there's no problem starting late. It doesn't matter if you haven't done some of the earlier modules, because they can be caught up, basically, is the point. I'm hoping today that there might be time to go back on any questions any of you might have from the earlier modules. So after we've completed this particular series of slides and questions on the conduct rules, we can certainly open the floor to any other questions you might have, going back on the other modules, which are about insurance, about maintenance, about the definitions and concepts in sectional titles. So that's an offer to raise any questions. As before, any questions we don't cover on the webinar, we can gladly respond to by email, and I'll remind you of my contact details or Karene's at the end of the course as well. Then just an apology, it seems there was a connectivity issue last week with the insurance webinar. So the recording that we made actually cut off at 23 minutes. So I don't have a complete recording of last week's webinar presentation, which I apologize for. Once again, I think it was a connectivity interruption which stopped the recording. However, we do have a client trustee webinar planned for next week on the 23rd on sectional title insurance. So what I will do is I will record that presentation next week, and we will make that recording available as an alternative. And the slides, I think I have circulated to almost everybody that requested. So the slides are immediately available, but the recording will catch up next time. And then, as I said, as you get the weekly invitations, the recording link for all the prior modules are captured in the invitation itself. So those are the introductory comments that I was hoping to make today. All right, so I'm going to now hand over to my colleague, Careen Coetzee. Careen's going to give us the legal framework which is relevant to conduct rules in sectional schemes, and I think that will be an important starting point from where the case studies will be interesting and relevant, and very good ways to reinforce some of the important principles. So thank you very much. Welcome once again. Thanks for participating. And Careen, may I please hand over to you.
Thank you.
Okay, Careen.
Thanks, Andrew. So yeah, if we can go to the slide. So basically what we're going to look, can you hear me?
Careen, you are breaking up. I'm worried about your connectivity. Are you connected on a network cable?
I'm on the Wi-Fi connection, Andrew.
No, Wi-Fi's not satisfactory, Careen. You need to be on a network cable.
Okay, that's unfortunately all I've got available for me.
Okay, well, do your best. It was breaking up, so do your best, and I'll have to step in if it's not clear enough.
Okay, so basically the first thing that we're going to look at is how to make rules. So in a sectional title scheme, there's 2 different types of rules. There's management rules and there's conduct rules. So looking at management rules first, the management rules deal with management issues, and the Sectional Title Schemes Management Act basically has prescribed management rules that is contained in Annexure 1 of the Act. To amend these rules, and generally in a complex, these management rules are not generally amended, but it is possible to amend a unanimous resolution passed. And after it has been passed by unanimous resolution, you will have to get approval by CSOS before these rules will become enforceable. So just to quickly explain a unanimous resolution, it can be done in two ways, either of two ways. It can either be done at a meeting. At the meeting, 100% of all the owners present and voting must vote in favor, and you need an 80% quorum in number and value before you can vote. And a unanimous resolution can also be done on a round robin basis, and then 100% of all owners must vote in favor. And again, once the unanimous resolution has been passed, the rules also must be approved by CSOS before it becomes enforceable. Then if we go to the next slide, we basically look at conduct rules, and this is what is generally most complexes customize their conduct rules, and the prescribed conduct rules are contained in Annexure 2 of the Sectional Title Schemes Management Act. And to amend conduct rules, you need a special resolution to be passed by the owners, and after that, it also has to be approved by CSOS before it becomes enforceable. To get a special resolution, you can also do it in two ways. You can either do it at a meeting, or you can do it on a round robin. So if you do it at a meeting, normal quorum has to be present, which is either 1/3 or 2/3 of the owners, depending on the number of units in the scheme. And then 75% of those present in number and in value must vote in favor of the resolution. To do a special resolution on a round robin, you need 75% in number and value of all owners to vote in favor. And then again, once the special resolution has been passed to approve the rules, it has to be approved by CSOS before it becomes enforceable. So if we go to...
Do you want to maybe just talk about exactly how do you get it approved by CSOS? So what documentation do they want to see? Do you write to them, etc.? And how do they confirm to you that the rules are approved to then have some sort of documentation to prove that it's effective and effective?
Yeah, Andrew, if we can go to the next slide, that is basically what you receive from CSOS. So the process involved is there is a prescribed form that you need to complete, that you need to send to CSOS together with the approved rules and the minutes of the meeting where they were approved. CSOS then basically goes through the rules. They approve or don't approve. Sometimes they come back and say you have to change certain rules before they will approve it. But finally, once they're happy and they've approved it, they give us a certificate like the one on the screen that basically states and is stamped by CSOS, signed by the acting chief ombudsman to state that the rules have been approved. And they also stamp the rules that you've sent them. So that is basically the proof that these rules have been approved by CSOS and that they are now enforceable.
And only from that effective date which appears on this approval certificate.
Are they enforceable? Yes, Andrew, only from that date.
Okay, thank you.
Then basically to just give some pointers on enforcing the rules, one of the things that CSOS will ask you is if you have followed an in-house dispute resolution procedure. So we just basically give you an idea here, a suggestion of what you can include in your in-house dispute resolution procedure to basically say that complaints must be in writing because it's easier to then keep track of complaints. You can also put in there that anonymous complaints will not be dealt with. Another suggestion is that you say in there that on receipt of a complaint, the owner must be given the opportunity to state his case once he has been notified of a complaint. And then also you need to include what steps need to be taken in order for the trustees or directors to verify the complaint. That can also be important in terms of the type of complaint that you've received. And then just very important that for a fine, a lot of people just want to fine people or penalties or something like that. But unfortunately, there has to be a procedure followed before you can give a fine or a penalty to somebody for breaking the rules. So the first one is that the fines must be provided for in the rules. If the rules do not provide for fines, then you cannot fine somebody. The second point is that the owner must be given the opportunity to state his case before he is fined. So it is important that in your in-house dispute resolution procedure, you have the opportunity for the owner to meet with the trustees, to state the case, to give his feedback in terms of the complaint before he is fined and not after he is fined. And then also the third point is that fines must be reasonable. You cannot fine somebody 1,000 Rand for dropping a piece of paper on the common property. It must be a reasonable fine. And then also, once this procedure has been followed, it could be referred to CSOS. CSOS is an affordable dispute resolution mechanism, but as I said, they will ask you if you have followed an in-house procedure first to try and resolve the issue. If not, then you can go to CSOS. They only charge 50 Rand for a conciliation, which is basically them sitting around a table with the parties trying to facilitate a resolution to the problem. If that is not possible, then it is referred to adjudication, and you only pay 100 Rand for adjudication. But yeah, as Andrew said, next week we're going to talk to CSOS. We're going to have people directly from CSOS office, and they will be able to answer all questions with regards to that.
Karina, question maybe at this stage, just about what happens if a trustee or even a chairman transgresses a conduct rule. How should that be dealt with and escalated?
In exactly the same way as if it was any owner. If a trustee is in transgression of the rules, the other trustees will have to investigate, and the other trustees will have to take the matter further. Even if it's the chairperson, nobody is above the law. Everybody has to comply to the rules, and everybody has to adhere to the rules.
Okay. Now, Karine, also, whether a fine is reasonable is slightly subjective. What I find reasonable, you might not find reasonable, for example. Can you assume if CSOS has approved the rules in the way that you've explained and their fines provided for in those conduct rules, would that imply that CSOS finds those fines reasonable to be enforceable?
Yeah, Andrew, if in your rules you say that if you park on common property without permission, we will fine you 500 Rand. And it's specifically stated like that in the rules, and CSOS approved those rules, then it is fine.
Okay. But again, if the owner deems it unreasonable, they would have the opportunity to test the reasonableness and to escalate it to CSOS after they've lodged their appeal with the trustees, and they're welcome to then test that with CSOS directly, I assume.
Yes, that's correct.
Okay, thank you.
Okay, so if we can go to the next slide, please.
Right, now I'm having trouble moving it to the next, sorry. Let me see what's going on here. Just maybe a question, Karine, while I try and get to the next one. There's a question here: in the absence of an in-house dispute resolution procedure, what applies? So another way of saying it is, should a dispute resolution procedure be included in the conduct rules to be clear, or what is the default if it's not included in those conduct rules?
If there's no formal in-house dispute resolution contained in the conduct rules, it doesn't mean that you don't have such a procedure. You can have an informal procedure. It's basically just CSOS is just asking that, did you try to resolve the dispute on your own? Did you speak to the person did you speak to the trustees? Did you speak to the person who is breaking the rules? Did you try to resolve it in-house? So the suggestion is that you have a formal dispute resolution procedure in your conduct rules, but if you don't, you can still follow an informal procedure where you just basically talk to the parties involved, try and resolve it internally. But if it's not possible to resolve it internally, then you can refer it to CSOS.
So, Karine, would it be correct to say that, practically speaking, any owner who is fined or held up on a conduct rule would have the opportunity to dispute that by writing to the trustees and lodging a dispute to say they disagree, they would like to dispute that particular conduct rule breach issue, and they would like an opportunity to either present their case at a trustee meeting, or they could give their argument in the written form and then, do it in that way. And either they would get a positive response or not. And if they were not satisfied with the positive response, that would then give them the opportunity to escalate to CSOS to take it further.
Yeah, Andrew, they should be given the opportunity to state their case before they find. They shouldn't first be fined and then given an opportunity to state the case. They should be given the opportunity first. And once they've given the opportunity and the trustees have taken all facts into consideration, only then should they be fining the person.
Okay. A question here from Andre. Why does CSOS charge 50 Rand, which is the dispute lodgement fee that you mentioned for mediation, and then take money off the levy? So maybe I'll answer that one, Andre. So on every sort of community scheme levy is a CSOS levy, which is prescribed in the CSOS legislation. That levy is actually calculated on a formula. We might talk about that next week, but basically that pays for the CSOS service and administration. So the CSOS levy, which is raised on every levy account based on a formula capped at 40 Rand per unit, is actually an administration levy paying for the CSOS officers, their staff, their systems, and their administration. The 50 Rand refers to a dispute lodgement fee. It's the cost to lodge that dispute with CSOS, and it's the additional fee for that dispute to be either mediated or there's an additional charge to have it adjudicated, typically because those processes are outsourced to external consultants, and there is some cost to do that. I suppose also this fee is a gateway fee, meaning that they want people to be serious and committed to lodge these matters, and hence they're raising a small fee, which anyway is significantly lower than a legal process. So it's a really cheap fee compared to the alternative of escalating to court. Do you agree with that, Karine? Anything to add?
Yes, absolutely. Andrew, if you look at legal costs, it is enormous. So CSOS is specifically there to be an affordable dispute resolution mechanism. And yes, the CSOS levy is used to fund them. But yeah, as you said, they just charge a small admin fee for conciliation and adjudication.
Okay. Then, Karine, we get this query or complaint very often where trustees appear to disregard the conduct rules and they appear to see themselves as above the conduct rules. You spoke earlier about, trustees can equally be, held accountable for the conduct rules. The enforcement of the conduct rules can equally be sort of enforced against trustees, chairmen, owners, and residents, all the same. But, what is the opportunity to apply pressure to a trustee to resign or a chairman to resign if they flout conduct rules? Is there any linkage there in terms of...
Anybody can be asked to resign as a trustee because the idea is that the trustees have to set an example for the owners. So they can be asked to resign, but the only way that a trustee can be removed or can be forced to resign is if they if there is a court order against them for breaking the rules, or a court or adjudication order from CSOS for them breaking the rules, or a court or adjudication order from them being arrears with their levies. You can always speak to a trustee and ask them, listen, do you not think that you should resign because you're not being an example to the other owners?
Okay, so only the physical court order or the adjudication order from CSOS are grounds to impose resignation on a trustee or a chairman?
Yes.
Okay.
Yes, Andrew.
Otherwise, it would be voluntary. They would need to be persuaded or negotiated or kind of facilitated, but voluntarily resign in writing to then step down.
Yeah, the owners can also request that a special general meeting be held to vote out this trustee, because remember, the owners voted in this trustee, so the owners can also vote out a trustee, but you have to call a meeting for that. It has to be on the agenda for the meeting. that you want to remove Karine Coetzee as a trustee, and then it's voted on at the meeting, and then a trustee can also be removed.
Okay. All right, there's an important question here about tenants, you know, and the application of the conduct rules to tenants and how that's done. So maybe if I can just clarify, so the conduct rules are typically enforceable against the owners in a sectional title scheme. They would typically only be enforceable against a tenant if the conduct rules were a part of the tenant's lease. And for those reasons, it's strongly recommended that all owners make the approved conduct rules an annexure of the signed lease agreement so that they can be enforced against the tenant, which makes it much more effective for the conduct rules to be equally and consistently and fairly enforced against all residents, whether they're owners or tenants. So it's really important that owners are aware of that. They're aware to include the conduct rules as part of their lease agreements, because the body corporate only has, or the trustees as the agents of the body corporate only have the power to enforce the conduct rules against owners in the first instance. So Karine, you agree with all that? Eh?
Yes, Andrew, the owner is ultimately responsible for his tenants, his visitors, his employees, all of that. So the relationship is between the body corporate and the owner, and they can only enforce the rules on the owner because the owner is responsible.
Okay. We're getting quite a few questions here about, you know, do fines apply to certain circumstances, you know, for example, where people park incorrectly in the wrong lanes, etc. So, you know, all complexes are different. They've got different configurations, different conduct rules typically, etc. I think the important point to make is the conduct rules need to be clear. They need to be very well defined, and they need to be very unambiguous, so they can be enforced correctly, fairly, and reasonably. So it doesn't help if the conduct rules are vague. It doesn't help if they are not matched to the circumstances or what's not going well or correctly at a complex, because then it makes it easy to challenge them. It makes it easy to, you know, question their application or their accuracy or even their fit to the circumstances concerned. So it wouldn't be possible to comment on particular scenarios without actually checking the wording of the rules, whether the rules are correctly approved by CSOS in the way we spoke about earlier, with the CSOS approval certificate document that you saw. I think the point really is clarity of the rules, you know, the ambiguity must be eliminated so they're easy to interpret, they're accurately interpreted, they can be absolutely well applied, and that would give a much better chance of effective enforcement of the conduct rules. So that's a really, really important point. And, you know, just to add to that, if you're finding that the rules are not matching the requirements, they're not helping to enforce the right conduct and eliminate challenges at buildings, that would be grounds to look towards updating or modernizing or addressing deficiencies in the conduct rules, addressing the gaps. And Karine spoke about how that's done through the resolutions at general meetings. And typically the trustees would then workshop changes to the rules, ways of improving the conduct rules. They would then, you know, write the changes that they would like to propose, and then those proposals would be voted on at a general meeting to update the rules, as Karine explained, to then have better, more enforceable conduct rules to address the issues being experienced on site. So I think that's another really important point. And I think caretakers play a very important role in identifying those gaps or those challenges with the conduct rules and making recommendations to improve them, which the trustees and the managing agents can take further to get it right. So it certainly would make your lives as caretakers, the trustees' lives, far easier if the conduct rules are accurate, effective, well targeted at the circumstances of your complexes. And I think it makes a big difference to residents as well, because it eliminates doubt, it creates clarity and certainty, and typically people's behavior then becomes modified in the way that the conduct rules are applied and enforced, and especially if they're enforced consistently. So I think that's just an important point to make to answer some of the questions coming through. Elizabeth, I think we've talked about voting out a chairperson. So as we said, a chairperson would need to voluntarily resign After that, the other trustees would then meet to elect a new chairperson. Otherwise, a general meeting would be required to elect new trustees. And then at the first trustee meeting, a new chairperson would be elected, thereby changing the old chairperson. So it becomes a voluntary process unless there's a court order, as Karine said, either from a court or from CSOS, creating a judgment against an existing chairperson or trustee, which would require them to change. So I think that's important just to note. Nico, a special general meeting or an annual general meeting are opportunities for new trustees to be elected. And as new trustees are elected, the old trustees actually then step out of office, and the new trustees elected become, the new trustees that will carry on from after the general meeting. So there's a renewal point at a general meeting. There's a vote which then elects either the same people or new people, and that would be a way to create change in terms of who's currently a trustee or the chairman. So hopefully that answers that question. Karine, there's no time limitations on approved conduct rules, aren't there? They just continue indefinitely until they might be changed. Is that correct?
That's correct, yes, Andrew.
So they don't expire in any way.
No.
And then, Karine, maybe just talk about new developments. It's obviously easier for a developer to create, accurate conduct rules, modern conduct rules to meet the requirements of a sectional title building. Those still need to be registered, do they not? But it's certainly quicker if the developer does it from the outset at square one, and then new owners obviously become aware very quickly from the outset as they buy into the complex what those rules might be.
Yes, Andrew, with a new development, the developer must either customize the rules and also get them approved by CSOS, or they can have a certificate saying that they work on the prescribed rules of the Act. So that decision is up to the developer. But then even if the developer made certain rules and had them approved by CSOS, as I explained, the owners can still come afterwards and change those rules. They don't have to stick with those rules. They can change the rules at any stage.
Okay. And a question here about where does one get copies of the rules, the management rules or the conduct rules? So I think the managing agent should have copies which can be made available. It would be a good idea for caretakers and trustees to have copies of the rules with them in a file so they can refer them to me easily or electronically. And there are many apps that are now available to all residents where the management rules and the conduct rules are then linked onto the app, and then those residents can download them immediately and have the copies available to them. And we asked all the time to email those conduct rules or management rules to owners or residents. We gladly do that free of charge if it's emailed. And also many estate agents will ask for copies of those rules as well to make them available to prospective buyers so that they can be aware of the rules before they buy into a complex. So they should be available, they should be easily available, and those would be the circumstances to look out for to get the management rules.
Yes, as the rules are also sent to CSOS when the complex is registered with CSOS. As part of the registration process, you also have to send the rules to CSOS. So if you want a copy of your complex's rules, you can also ask CSOS.
Okay. Karine, I've got a question here which also comes up very often. I'll just quickly summarize it. So the trustees are refusing direct contact from owners and residents. They're insisting on correspondence going through the managing agents. The managing agents record the email, theoretically forward it to the trustees, but there's no response. The question is the situation legal? How does one know that the correspondence is getting through to the trustees? And what does one do if there's no response?
Yeah, unfortunately, we see that often that the trustees prefer to work through the managing agent. It is, in a way, it is understandable because they have to face these owners. It's your neighbor, you live next door, you don't want confrontation. So they prefer to work through the managing agent. Unfortunately, if you feel that the trustees and the managing agent are not responding, then you can again, refer the matter to CSOS, or if you are unhappy with the way your trustees are dealing with complaints and or not responding to complaints, then you also as an owner have the opportunity with the backing of at least 25% of the owners. As we said, you can then ask a general meeting to be called and you can vote in new trustees. So the owners always have the ability to vote new trustees if they're not happy with the way the current trustees are dealing. But yes, you also have CSOS as a dispute resolution mechanism.
Karine, I think it's also fair to say that, you know, a workaround might be that owners can look in the last annual general meeting minutes or special general meeting minutes and see who was elected as a trustee. And then any owner can request the names and contact details of owners in a sectional title scheme, and that's provided for in the legislation. And they could trace the contact details directly themselves in that way. So that would be a workaround. It obviously takes some time and some effort, and it's not ideal. And we would certainly recommend that trustees are accessible, they are transparent in their communication. And personally, I think it goes a very long way where trustees respond quickly and decisively and are approachable to owners, because things tend to flow and move more quickly and issues can be resolved more constructively in that sort of way. But, you know, as Karine said, many trustees are, you know, protecting their privacy, they're protecting their time and their capacity. They would like the managing agent to filter and assist with responding to queries as much as possible. They're also not always confident of how issues should be resolved. And those are some of the reasons why we see that gatekeeping and filtering of correspondence. So it's not uncommon, but there are ways of trying to address it, and certainly ask the portfolio manager you work with for advice and guidance and assistance as a first step as well. So I think that's quite important too. We're going to move on shortly. Just a question here from Santa. If a chairman resigns, basically the remaining trustees would need to meet and they would need to elect a chairman from the remaining trustees. If no one's prepared to be elected as a chairman, or no one makes themselves available as a chairman, what happens then, Karine, if the vacancy remains? Would it need to go to a general meeting to elect a new group of trustees from where a chairman might be elected, or how does a group of trustees continue with no chairman?
Yeah, in terms of the Act, you have to have a chairperson. So yeah, either they have to, as Andrew said, call a general meeting, elect new trustees of one who will be willing to be a chairperson. There's also the opportunity, if nobody wants to be chairperson, nobody wants to be trustees, there's also the opportunity for the owners to appoint an executive managing agent, who then basically takes over the functions and powers of the trustees who act as trustees. That is also a possibility if nobody is willing, but yes, you have to have a chairperson.
Okay. A question from Daniela. What percentage of owners can vote out the current trustees? So Daniela, that would be the general meeting approach where new trustees are elected. So really it would be a quorum. So in a complex, is it more than 4 units, Karine, where you'd need 1/3 of the owners would form a quorum? That meeting would then be correctly convened if the agenda was sent out 2 weeks before the meeting, and that quorum of owners can then elect new trustees. And as the new trustees are elected, the old trustees are then replaced and the new trustees continue. So it's really the quorum of a general meeting correctly convened, which would then replace trustees. So hopefully that answers your question there. Karine, are there any such things as subcommittee members, sub-trustees?
No, Andrew, the Act doesn't make provision for that. The Act only makes provision for trustees to be elected and can act and have the powers of trustees and to fulfill the function of trustees. But I have seen in complexes where the trustees form a subcommittee of, for instance, they have a project where they want to upgrade the gardens. So they ask owners who will be willing to serve on a committee to investigate the matter, to get quotes, to put together a proposal, and that is then tabled at the next trustee meeting, but it remains the authority of the trustees to make the decisions. The subcommittee has no powers, has no authority to make decisions, but it could be an informal committee to do the legwork, to do the research. But in the end, the trustees are the ones making that have the authority to make decisions.
Okay. All right, we've got a few more, but let's carry on and we'll come back to the next questions from there. Okay.
Okay, so the next couple of slides is basically just from complexes that we manage, is an example of how you would put it in your conduct rules if you want to charge owners fines or penalties. So this is just basically an example where you can have the wording of it, where they say that the trustees will have the right to fine. It also states that the owner has the opportunity to appear before a committee of trustees to state his case before he's fined. The owner will be given the written details of the alleged breach and notice of the hearing where he can state his case. And then it just gives a little bit of background of this hearing and how it will be dealt with. And should the owner then still be fined, the fine will be debited to his levy account in this example. And then they also say that they will have a schedule of fines. So in this specific complex, they had in their rules, they had specific fines for specific breaches. And then they also have the stipulation here that should the owner fail to appear at the hearing, so we're giving the owner the opportunity to state his case, but should he fail to appear, then the committee can make a decision in his absence and just notify him in writing. And should the owner then still dispute the fine, they have the opportunity to go to CSOS. So that's just basically an example of conduct rules that were made and approved by CSOS with regards to the fining system.
All right, so I'd just like to emphasize yet again that it's so important that they're clear, that they're detailed, that they're unambiguous, and therefore much easier to action. You know, it's really important that caretakers, trustees, managing agents are well informed about the conduct rules. They should have copies, they should read them, they should be aware of what's contained, so that knowledge and awareness can be applied correctly from the outset, from engaging with the owners and residents, from the feedback and communication associated with issues and the way that they are being addressed, and you know that the information is accurate and correct. So, you know, please do be informed about your complex's conduct rules. Please do have a copy. Please do make sure that they are approved by CSOS to be enforceable. If you do not have a CSOS approval, the default would be the prescribed conduct rules or management rules, and in that case have a copy of those so that you do know what is provided for. And by all means, if you think the gaps, define those gaps, engage with your trustees about those gaps and trying to get them closed, because I think your lives and the lives of the trustees and the residents will be greatly improved if those gaps can be closed. So just some closing comments on that.
Yeah, just Andrew, just to add to that, so basically before the Sectional Title Schemes Management Act came into force on the 7th of October 2016, the rules were filed at the Deeds Office. So if you have a complex with rules filed at the Deeds Office before 7 October 2016, they are still enforceable. They don't have to now all of a sudden be approved by CSOS. It's only for complexes after the 7th of October 2016 that amended their rules that they have to be approved by CSOS. Okay, so this in this example is basically just the top snippet of the application form that you would send to CSOS. But yeah, as we said, CSOS is going to have a full presentation next week where they will go through the whole process of how to make an application, what must be completed in the form, and given to them with regards to a dispute resolution.
Maybe I can just say CSOS has a reasonably good website, which would be www.csos.org.za. You can see top right what the format would look like. On the CSOS website, there is a section on the whole dispute resolution process, It describes how it's done, what's required. It's got the documentation that you're seeing here, and it explains, how to lodge it. So, it is there. Any owners should be advised to look on the website to get the necessary information and forms, and they should do it sooner than later to escalate decisively. And I found that, a lot of frustration around the conduct rules comes from people not knowing how to enforce them or what to enforce and how to escalate quickly where the right result or the right response is not being achieved. So with the correct knowledge and the correct process in mind, the escalation should be fast, it should be decisive, it should be accurate. And that should eliminate a lot of the frustration, because the process will move forward a lot quicker than that. So I think that's just some important practical points and tips to raise around that. Karine, an important question. What happens to the money from the fines?
It just becomes part of the body corporate funds, Andrew. It goes into the body corporate bank account, and it becomes part of the body corporate funds.
Okay, because it's collected with the levies and with the levy account.
Yes.
Yeah. There was a question about daily fines. So apparently some complex was fining an owner daily while the transgression was continuing. I think once again, it goes back to the point, is that reasonable? There should be an escalation or an appeal process. The appeal process should be utilized. If that doesn't resolve the dispute and it doesn't sort of, amicably resolve the issue being, cleared, there is the escalation to CSOS to test whether daily fining is reasonable and whether the conduct rules were correctly applied and enforced. So,
I don't think CSOS will approve a rule that says you will be fined daily.
Yeah, I don't think so either. But again, it just comes back to what one person thinks is reasonable isn't always the same as another, because it is fairly subjective. But, by all means, internal dispute resolution must be used first, with the appeal, with, engaging in a discussion and a negotiation, and CSOS is there where that fails to resolve it. And typically, a CSOS approval would confirm whether the fines provided for were deemed to be reasonable or not. If the daily fines weren't in a approved conduct rules anyway, well, then it's a non-starter. By definition, they're not enforceable and they're not legally applicable. So I think that sort of is an answer to that particular one. All right, so let's pause there. Karine, I've gone forward to the next slide.
Yeah, that's basically most of what we've said, but just a little list of practical tips for enforcing rules. As Andrew said, the caretakers play a very important role in assisting the trustees and the managing agent to enforce the rules, because they are there. They are the people at the coalface. They are on the premises. They're walking around on the premises. They see what's happening. So they play a very important role. And yeah, as Andrew said, it's important that everybody has a copy of the rules. If you have a notice board, if you have a reception at your complex, put it on the notice board so that it's there and it's clear for everybody to view. If you get a complaint, it's important to acknowledge that you've received the complaint in writing. Keep a portfolio of evidence so that it's not just he said, she said. And yes, as we said, escalate to CSOS if internal remedies fail. Where there's breaches, then it's important to look at the evidence, look at all the facts. Don't play favoritism, things like that. It is important to look at the facts of the case, and each case must be handled separately and differently. So that's basically that.
All right, thank you, Karine. Maybe I could just add too that, if somebody approaches, if I was a caretaker or a trustee in a complex and somebody approached me with a conduct rule issue, the first question one could ask is, have you read the conduct rules? Do you have a copy of the conduct rules? And if not, let me assist you to get a copy to be correctly informed about what is enforceable and what is accurately expected in terms of the conduct rules. So that would be step one, and that would be a good first engagement in terms of a resident or a conduct rule dispute. Also important, just to emphasize, is the evidence. what evidence is there to test whether a conduct rule breach has actually taken place. And unfortunately, we see very often complaints around the conduct rules. The common ones are parking, laundry, pets, noise, washing on balconies, etc. And, let me just reassure everyone that breaches of the conduct rules and conduct rule disputes are very, very common. They happen in most complexes. It's not unusual to have this fairly often because residents are living at close quarters, sharing common property, sharing common amenities, living side by side, and everyone's different. There's diversity and different preferences, if I can explain it that way. So it's not uncommon. This happens on a regular basis. But certainly make sure that people are aware, they have the correct documents, they have the correct understanding of the enforcement, the approval, the legalities, and then please make sure that there is a way of collecting the necessary evidence to validate whether the conduct rule dispute is valid, correct, and can be proven, if I can put it that way. We get many, many disputes that are reported where there's a lack of evidence. There's no corroborating evidence. It becomes very difficult to determine, is it actually a conduct rule dispute or is it a personal issue between owners? And it's very difficult to impose fines or other remedies provided for in the conduct rules if there's no evidence to support it. And if it does get to CSOS as a dispute and as an adjudication, the adjudicator will be looking for evidence and ways of validating the conduct rule breach to make a ruling. And if there's no evidence, as for a court of law, it will be very difficult to come up with a ruling against the perpetrators. So it is important that mechanisms are put in place with, for example, neighbor statements or affidavits, CCTV cameras, recordings, a security guard being called to be a witness, a recording and an OB book for the security guards. All of those things are important to find the necessary evidence to make sure that the complaint can be enforced and can be validated as a conduct rule breach. Okay, thank you very much, Karine. We are going to go on to the case studies now. So, Helene, I'm handing over to you for your first case study, please.
Good afternoon, everyone. All right, so just in terms of the case studies, I'd like to build on what Andrew has already mentioned. And in terms of our main challenge when it comes to enforcing conduct rules is the fact that initially, when we submit a complaint to a member, one of the first responses is, "It wasn't me." So it is very important for those of you like caretakers on the ground who are in a position to play that very important role of being able to gather evidence, to be able to know where to look. And everything is not always cut and dry. So just as an example, we have on Google Play, there's a lot of decibel meter apps that are available, which a caretaker can download on a smartphone and be able to record a noise complaint to give us some type of proof to address it. I know Andrew's already mentioned security OB book entries, which can also be used. If you can move to the next slide for me, Andrew.
All right, sorry, I'm getting there.
Not a problem. It very often happens that someone causes damage to communal areas, and one of the very important and as you can see from the pictures, this was quite a big incident. One of the important issues is always to try and get as much evidence as possible, specifically for when we need to apply or when we need to prove it at CSOS or a court of law. In this example, we can look at getting an OB book entry from the security guard, a statement from the security guard. As a caretaker, you can try and get the actual resident or the person who caused the accident to actually sign next to the OB book entry, which already gives us a better foot to stand on. You can move to the next slide for me, Andrew. In terms of this, sometimes infringements of conduct rules aren't really only because of aesthetic value. There might be something else. There might be, in this case, we have storage of items on a patio, which technically forms part of the section in this specific complex, but it causes an insurance risk. So it causes a security risk. It also attracts further security problems in the complex when things are easily accessible. I mean, this is on ground floor, anybody can walk past it. In this instance, we always have the opportunity, and this is what I mean about thinking outside the box. If the owner is not willing to adhere to it, we can approach the body corporate's insurance broker and ask the insurance broker to write a formal letter to the owner confirming that it creates a fire risk for the complex. So that gives us an additional foot to stand on when we need to try and address these matters. We can move to the next slide. I think you have mentioned it.
Sorry, I'm just trying to answer questions.
Not a problem. So in this example, it's just an example of washing over a balcony. Now, this, as you can see, is quite a large carpet that was hung over the balcony. This doesn't necessarily only look bad, but the amount of water that it drips down might also cause damages to the building itself, or to the balcony below, or to items stored on the balcony below. So there's a lot of additional items that we need to take into account when we're enforcing conduct rules. As an example, parking was one that Andrew mentioned. There's always the possibility of wheel clamps, making sure that your rules provide for wheel clamps. It's very difficult to have a vehicle towed from within a complex. But you can institute wheel clamps depending, of course, on making sure that you cover any possible liability for damage to the vehicle, that type of thing. One of the common other issues that we have is overpopulation in a unit. Overpopulation can be, you can make use of your access control system to check movement from and to a unit, how many people are moving in, how many, let's say, for example, we have a tenant that has a lease, and on the lease it says he's allowed a maximum of 3 people. Only issue 3 tags for that specific unit. So there's a number of processes and outside the box theories that could also be used to try to implement conduct rules. And even if we have to go to, and remember, it's not only the member that can lodge a dispute with CSOS. The members can also lodge a dispute against the body corporate for not enforcing conduct rules, in which case we would have to prove that we have gone to the extra extent of trying to enforce those conduct rules on owners and consistently enforcing those conduct rules on owners.
Helene, there was a question about maximum number of residents or occupants of a particular unit. Have you seen that provided for in the conduct rules, or is it rather a bylaw restriction?
I know that some municipalities have provided for that in their bylaws. There are, however, some municipalities that do not have that provision. So it is best to make sure that you comply with the municipal bylaws, and if there's nothing there, to at least then try and have something approved in your conduct rules as well. We have many conduct rules where there's a stipulation on 2 per bedroom, but then we also have the added challenge of subdivision inside units to create extra bedrooms, which then falls under different legislative framework.
Okay, and I mean, maybe just to say a practical point to enforce that, you know, it would be unfair to expect a caretaker or a trustee to inspect units and count people at home and invade people's privacy, and many people are out at work during the day anyway. So a better practical approach would be through access control and registering the correct number of occupants based on the size of the unit, per the plans or the floor plan, or what the managing agent would normally be able to provide. So things should be, you know, enforceable more practically, you know, respecting the logistics of invading people's privacy inside a unit. Okay, there we are.
I think this is Gillian's.
Are we on to Gillian's? Okay, thank you very much, Gillian. We might well come back to you for questions shortly. Gillian, thank you. If I could hand over to you for your case study, please.
Yes, sure. Thanks, Andrew. This is in fact based on an actual dispute which I was involved with some years ago. The slide that you're looking at is the portion of a sectional title plan of a large sectional title apartment block, which covers an entire block across 4 streets. There are 6 entrance foyers. You'll see them on the slide highlighted in yellow on the plan. And for the sake of this presentation, we'll call them foyers A to F. The large, expensive apartments are built in the center of the building, facing Beach Road, which is on the left-hand side of the slide, whilst the smaller apartments are situated on Oliver Road and Murray Roads, which are at the bottom and the top of the slide. So if you can go to the next slide, please.
Right, let's work through all the arrows. Sorry there, Gillian. Okay, those are the entrances. Right.
Yeah.
Is that the next one?
Yes, I'm not sure why the animation is here. It was taken off, but anyway, we'll continue. So that's Mrs. Null over there. She owns a small apartment on the Oliver Road side of the building, and her access tag only allows her to enter the building from the small foyer A, which is 1 passenger lift. And if you click, you should get another animation up there for Mr. Peterson, who owns a large apartment on the Beach Road side of the building. You'll see there, and his access tag allows him to enter through foyer D. That's the main entrance of the building, which is 2 passenger lifts. And on the next slide, you'll see Mrs. Null commutes by bus. The closest bus stop is on the Beach Road side, right outside the main foyer. And this means that Mrs. Null must walk from the bus stop right round the block to foyer A to access the building. And Mrs. Null, because she was elderly, found this to be a real inconvenience, especially during the winter months, where she has to walk a long distance in the cold and wet weather. She wrote a letter to the trustees requesting that her access tag allow her access to all the foyers. The trustees met to discuss and consider her request and agreed that the access control at the building had been set up in this manner and had been in place for many years for the sake of security as a house rule. The building supervisor at this particular building was instructed by the trustees to program all the access tags for all the residents in this manner. A letter was sent to Mrs. Null informing her that her request had been denied. Mrs. Null was not happy with the trustees' response, and she lodged a formal dispute with CSOS, which eventually proceeded to adjudication. Mrs. Null stated that the current access control setup discriminated against the owners of the smaller apartments. The body corporate was ordered to allow Mrs. Null access to all the foyers, and that was on the basis that house rules, firstly, are not enforceable. Trustees cannot make rules, as Karine mentioned in her presentation. Unanimous rules are required to create management rules and special resolution for conduct rules. The other facts that they mentioned was rules must be reasonable, and rules must apply equally to all owners of all units. So you can't have some rules which apply to certain residents and not to others. Thank you.
Gillian, can you just add a level of practical detail while you completing? So how long did it take from lodging the adjudication paperwork to call the parties to the hearings? What documentation was presented? Who was present? And how long did it take from the actual adjudication meeting to provide the written ruling?
So firstly, when we were notified of the dispute application from Mrs. Null, the trustees were given an opportunity by the Ombud to respond in writing, which we did, which they then duly did. We then received a further notification from the Ombud. I would say, if my memory serves me correctly, it took about between 7 to 14 days, notifying us of a conciliation meeting. It was an in-person meeting at their offices at the time. So the trustees were present, the applicant, the complainant was present, and the managing agent, we also attended. At the conciliation process, each party was given an opportunity to state their case. The Ombud also had a conciliator present in the room who facilitated the conversation, but couldn't make any decisions or any ruling per se. Unfortunately, at this conciliation, the parties still couldn't reach an agreement. The matter then was proceeded to adjudication. It proceeded quite quickly. I think within that month, we got a date for the adjudication. This was where the formal process began. where owners, or whether the parties at least, could submit any evidence, which Mrs. Nell did. She submitted a letter. She had an explanation of, where the foyer was, where the bus stop was, and the fact that the foyers were in fact common property. She was correct. The trustees couldn't or prove or show that the rule that they had in place, whilst in their belief was for the benefit and security of all owners, it wasn't a registered and enforceable rule. And on that basis, we received the actual physical ruling from the Ombud, the outcome, within a week after the adjudication. So the process was quite quick and effective from start to finish. In my opinion, it was a fair process. All the parties were given fair opportunity to state their case.
And did the trustees arrange reprogramming of the access tags directly after the ruling was provided?
They did. Correct, they did.
Okay, so that was a satisfactory outcome of that. Yeah. Did they have to update their conduct rules after that, Gillian, because the existing ones were incomplete or not correct?
They didn't. And I don't, in my personal opinion, I don't know whether those conduct rules, had they updated it to restrict access to certain foyers, would have been approved on the basis that the access foyers are common property and they belong to all owners equally. So,
yeah. Okay, well, thank you for that. So we've got a number of questions which I think we can work through. We've got a little bit of time left, which is good. We've got about 25 minutes. So I will try and work through the questions, and I'm going to direct them to my colleagues who have probably a lot more experience than I have. So Helene, one for you, and we see this quite often as well. What should a caretaker or a building manager do where they get little support from the trustees and the chairman, who are not eager to get involved or correspond or take action in the event of a dispute, of a conductual issue, etc.? What would your advice be to that caretaker or a building manager?
I think it is very, and unfortunately it does happen in reality, it is very, very difficult because there's as a caretaker, they're employed by the body corporate, and as a result, they report to the trustees. So it is, there isn't really a mechanism for the caretaker, unless they are an owner, to be able to address the trustees if they are not attending to or not supporting them or not giving them the required tools to be able to function in terms of that aspect. However, they can address it with maybe a lot of caretakers are owners in a sectional title, and that as an owner they have a different authority and a different mandate, and we've discussed quite a bit about the processes that could be followed to remove trustees or to replace trustees. But bearing in mind that such an instance, and it's happened very regularly as well, it creates a lot of animosity in a complex. And as far as possible, we need to try and build on a community approach, because when people don't get along, they're constantly arguing with each other. They are constantly working against each other, which makes it very difficult, not only for the caretaker, but for us as a managing agent as well, to be able to function efficiently. So first approach would be to request a meeting with your trustees and to actually put the concerns on the table and try and work through them and try and find a way around them, an amicable solution to it. Alternatively, as caretaker, bearing in mind that you are employed by the body corporate, whilst you report to the trustees, you are in essence an employee of all the members. You do still have the right to discuss an issue with a body corporate member to assist you to take it further on a different level.
Yeah, okay. So, I think just maybe to add, the managing agent can play a role in terms of negotiating a different approach with the trustees or guiding them accordingly. And I personally think many trustees are reluctant, partly because they're uncomfortable or are not confident of how to approach an issue or how to respond or what is the legally correct approach, generally because they might not have had the experience or the exposure or the knowledge of the legal framework. So, if that's the case, the managing agent can also assist, because this is our core business. It's what we do on a day-to-day basis. So through exposure and practice and repetition, we do see a lot of these common themes and common issues more than once, and that gives us the opportunity to advise trustees, to advise caretakers, to negotiate, to find a common ground between them, and to really try and achieve that. And if that fails, just remember that new trustees are elected at the next annual general meeting, and maybe there'll be a chance with a different trustee or a different chairman after the general meeting. So, remember that. And the other point is that more and more we are finding that less and less people want to be trustees. Less and less of them have time, have the interest. It's an unpaid role. It typically involves work after hours. The meetings can be long at night, after hours, etc. So, less and less people are willing to serve as trustees, and therefore that executive managing agent role, which is newly provided since October 2016, is becoming increasingly prevalent, increasingly of interest to buildings, to find a way to outsource the whole trustees function to a professional, to somebody that does this for a living, who has the experience, and hopefully that can then address that particular gap. So worth just being aware of that, and it is a trend that we're seeing, across the industry. Gillian, I'm going to ask you a question now. We also see this quite often. It's got to do with sleepovers. So visitors staying over for prolonged periods of time. I know some buildings provide for recoveries from sleepovers because they are using extra services, water, electricity. How does one manage sleepovers, and especially where sleepovers are being abused? People are staying longer than a visitor would be expected to stay, and potentially, the recoveries which are provided for are not being correctly managed.
It could also be a difficult situation, depending, if the rules don't provide for the length of a stay of a visitor, what is enforceable. One would then, I'm not sure what would be considered as a long stay or as a visit stay, if the rules don't stipulate. And certainly if the visitor is there for a prolonged period of time, and if it exceeds the amount of persons permitted to reside in that particular unit, then I believe the trustees need to make contact with that owner to inform them that they are either in contravention of the conduct rules, or if not a conduct rule, of the municipal bylaws, and ask them, what the plan of action is, when the visitor will be leaving, or otherwise ask that they please leave.
Okay, Karine, can you add a comment or two?
And as we said, it's very important that you have to have clear rules. So if you know that is a constant problem in your complex, provide for that in your rules. Make a conduct rule that provide for that, and how you would deal with that.
Yeah, so really without the rules and without the approved rules, nothing can be done about visitors and sleepovers and recoveries of any kind, or the security implications.
Yeah, Andrew, not really nothing can be done. There's a stipulation in the Act itself that says that an owner or an occupier cannot be a nuisance to other owners and occupiers. There's also a section in the Act that says that no owner can do anything that negatively impairs the value of units in the complex. So if you have, if an owner is constantly breaching or not, if there's no rule and they're not breaching the rules, you can still take the Act and say that you are being a nuisance to other owners. You are having a negative effect on the values of our units because of the people you have sleeping over in your unit. So there's always ways and means, but the best way is to have a specific rule on how to deal with specific things if you know that it's a problem in your complex.
Okay, thank you. Karine, just another one from you, which we see very often as well, and I think this is a common perception, and that is that the dispute resolution process with CSOS takes a very long time. And the question here is, more than 30 days have passed since an application was lodged or dispute was lodged, no acknowledgement, no comment on status, what can be done to see what's happening, to chase it, try and get it moving forward as quickly as possible.
Yeah, Andrew, unfortunately with lockdown, most of the CSOS offices closed down completely. So they currently have a backlog. Some of them are in operation, but they don't do face-to-face meetings. They just do online meetings and telephone meetings. So unfortunately, at the moment, they do have a backlog of cases. But if the complex is managed by Trafalgar, then the portfolio manager normally escalates the matter to me, and I escalate it at CSOS. I escalate as far as the chief ombud to try and get the matter resolved quicker. But yes, unfortunately, due to lockdown, there is a backlog, and it is taking a bit longer.
Okay, thank you. Helene, one for you. Do you see with the election of trustees that the chairman would ask the nominated trustee or the nomination candidates to introduce themselves, explain their experience and their credentials as a basis for voting and their election?
It happens very regularly, Andrew, where members who are nominated as trustees are asked to provide a short CV or their vision for the complex going forward, to allow the owners who don't know that person for a long period to allow them to make an informed decision. It is, however, not a requirement in the legislation that a trustee has to have a specific qualification. The legislation only goes so far as to say that it's a trustee's responsibility to ensure that they are aware of the legislation and how it needs to be applied, because they do carry certain responsibility. But in terms of actually qualifying to be a trustee, there isn't a specific skill set. We do prefer, especially when we look at trustees, that, and you'll see on many complexes, you'll find there are portfolios allocated, like a finance portfolio and a security portfolio and a landscaping portfolio. And in complexes like that, they do very often then focus on a skill set to be able to fit with a specific portfolio so that the complex can benefit from it. Or, for example, an attorney as a trustee to have legal input from the body corporate side, or an assisted legal background from the body corporate side. So yes, it does happen very regularly, but it isn't a legislated requirement.
Okay, thank you. I've got an interesting question here, Karine. Somebody's abusing the rules and the parking restrictions in the rules. They're getting fined, but they have enough money, they've got enough means to keep paying the fine because the parking is sufficiently useful to them. So the fine is not proving a deterrent. They're paying the fine because it achieves the parking, and that doesn't seem to be resolving the issue. So what can be done in that case where the fines are in place, the fines are being applied, the fines are provided for, but it's not achieving the correct result?
So basically, the trustees will have to then decide their course of further action. They can either go the legal route to consult an attorney, take the matter to court, or they can go to CSOS, which is a more affordable venue for them to use.
Okay. Gillian, can I ask you this one? So this is about noise. Now, Karine spoke earlier about there is a provision for disturbances to be escalated regardless of conduct rules, not specifying the exact time of noise being banned or restricted. So, you know, what is a disturbance that's enforceable outside of the conduct rules? And when would one be able to call in the police, for example, as opposed to following the standard dispute resolution process that we've been speaking about this afternoon?
And what I do think, you know, what Karine said, and just to emphasize that, is that, you know, no owner or occupier of a unit or a section should do anything inside that unit or section that causes a disturbance or nuisance or infringes on the right of any other resident or occupant. So bear that in mind, whether it be a noise disturbance or any sort of other disturbance. I believe, you know, in addition to calling law enforcement authorities, Helene also made mention of apps you can use to measure noise to see if it is a bona fide disturbance, or otherwise, you know, encourage good neighborliness. Knock on your neighbor's door, ask him to keep the noise down. If it persists, report it to the building supervisor or caretaker, perhaps through the security to intervene if necessary. And if still no joy, if it still persists, to the trustees or the managing agent to facilitate communication to that unit owner or occupier, and then as a last resort to the CSOS if still the behaviour doesn't change or if the situation doesn't improve.
Okay, good, thank you. Helene, pets are a very common cause of rule disputes, etc. You know, particularly dogs barking or dogs messing on the common property or cats wandering and, you know, wandering into other units and potentially also, you know, messing on either other people's property or the common property as well. You know, the rules again would need to specify which pets are allowed, what the process is to approve a pet, and also what process is followed or what is allowed in terms of an approved pet being disallowed. Do you have any tips to make the conduct rules applicable to pets as effective as possible, as fair as possible, and to limit pet issues in a particular complex?
I think one of the important items to mention on pets, Andrew, is to always try and ensure that when somebody is moving in or when somebody is applying for a pet, I know some people might move in without following the relevant process. But firstly, to have your process set out in your rules, as you've explained in detail, what process needs to be followed, does there need to be a sterilization certificate, all those types of information to put it in, and then also to make sure that you have a pet register, that you have photos of the pets that have been approved. Specifically with cats, it's very difficult sometimes to prove once again whose cat has been causing a nuisance if you don't have a pet register of some kind. In terms of actually enforcing it, it is unfortunately very difficult, especially because people don't tend to want to part with their pets, which we understand. But in terms of non-compliance, if they're non-compliant, we have specific dispute avenues that we can follow. We can issue them a warning, we can issue them a fine dependent on the rules, or we can approach CSOS. And yes, CSOS does take a certain period or a turnaround period to actually give you an order, bearing in mind that that order can be made order of court as well. But the only fast way to really address this is to approach the court for an application, to apply to the actual court, not to go to CSOS. That's the only way you would be able to speed it up. It's very, very, as I said, it's very, very difficult in terms of pets and in terms of how we can enforce those rules without actually going and waiting and following the correct procedure and following the correct route.
And pets can be disallowed if they misbehave in terms of the rules occasionally. And also just important to say that really important for estate agents to have copies of the rules and to carefully check with potential buyers that they're aware of the pet restrictions, that they're comfortable with the provisions for pets, and that they don't get involved in a problem from the outset. And that can happen if the estate agents are not responsible enough to, you know, check for the correct conduct rules, to have a copy to go through the rules with potential buyers, and to make sure that their circumstances are properly matched to the complex and its conduct rules as well. So in this case, it's always best to preempt a problem and to make sure that it doesn't arise in the first place. So just a point there. All right, I'm just looking, we're on about 48 to 50 questions. Karine, I'm going to come to you with a more technical general question. Somebody who owns a penthouse with an exclusive use, I think it's a veranda or balcony, can one construct a screen to cover washing hanging on it? So for example, if there's a rule about restricting washing on patios, can a screen be used to avoid the rule being infringed? And how does one go about getting that approval to put a screen to avoid the washing issue in the first place?
Okay, Andrew, first of all, you have to check if it's exclusive use in terms of the plans or the rules, if it's proper exclusive use. And if it is, it depends on the type of screen and how it is structured. Is it a fixture that is permanently added to that area? Is it a movable screen? Is it something that is just put up when there's washing and taken down when there's no washing? there's a lot of factors that have to be taken into consideration to be able to give an answer to that. It is a bit difficult to just give a short answer.
Okay. Helene, a question here from Kerry is, can the rules be different for owners versus tenants? So for example, this one is about pets. Can the rules say that owners may have pets, but tenants may not, for example?
No, Andrew, and I think we also mentioned this a little bit earlier in terms of the application of the rules, bearing in mind that the body corporate is not party to the lease agreement between a member and a tenant. We can only enforce conduct rules against an owner, and conduct rules, and even if the matter goes to CSOS, CSOS will also respond and say that the rules need to be consistently applied to everyone in the complex. The only way for us to enforce it is against the owner and to ensure that the owner then addresses it with the tenant. But we cannot apply different sets of rules to different resident types.
But Karine, just thinking about it off the cuff now, so yes, all units and the unit owners would be applied to the same rules, and that's a given. But the owner could actually agree differently with a tenant in the lease agreement. So it could be possible for the lease agreement to not allow a pet because perhaps the owner was worried about damage in their units and scratching or whatever. So through the lease agreement, the owner might have different arrangements and terms for a tenant, but still the unit would be applied to the same conduct rules. Does that make sense?
Yes, absolutely. The rule can say that you can have a pet, but the owner can say, I don't want pets in my unit. And as you said, they can do it then through the lease agreement.
Yeah. Okay. So it's just important to remember, the conduct rules applying to owners equally across the whole complex, but lease agreements would differ by tenancy as arranged by the owner or an agent on behalf of the owner. Very often the body corporate is not aware of the lease agreement, is not aware of a tenant, and is not aware of the terms of that lease agreement. It is possible to write into the conduct rules that the trustees should be provided copies of the leases, often for the reason to check that the conduct rules are included or how they are aligned to the conduct rules. Some body corporates specify that they would like to interview tenants, and often they do that to be aware, number one, but number two, go through the conduct rules so they have a very clear awareness, because very often it's lack of awareness that is the first and foremost problem in terms of enforcing the conduct rules. So just worth being aware of that. And I just go back to the point that a critical success factor would be for trustees and for caretakers to make sure that every resident and every owner has a copy of the accurate and correctly approved conduct rules, that they're visible on a notice board, that they have copies available to them to refer owners to if there's a dispute. It should be available on an app or a website or a portal if owners are using that. And that awareness, that accessibility, that transparency goes a very long way to preempting a lot of these issues. All right, any final comments, Helene, in terms of best practices for enforcing conduct rules well?
I think, Andrew, it's of paramount importance that the rules have to be worded correctly, as detailed as possible, and use every avenue everything that you can do to get evidence to be able to support your complaint. It is very, very important. And as caretakers on the ground, we as managing agents are not on site. We do not see these things. When we receive a complaint, it's very difficult for us to address that complaint and to enforce those rules unless we have that evidence in place. It makes our lives a lot easier, and it also prevents unnecessary disputes on infringements of rules.
Okay, thank you, Helene. Gillian, any closing comments on success factors for enforcing the conduct rules?
Yes, Andrew, just, in my personal opinion, in my years of experience, is that, whether or not the conduct rules have a dispute resolution process, that the trustees always apply the rules equally, and that the process that they follow when dealing with complaints is dealt with fairly to all parties concerned. Now, often we have scenarios where trustees default to implementing fines, And you can find owners, often they'll pay, and you'll find them again and they'll pay. And if the implementation or imposition of penalty or fine doesn't result in the desired change in behavior, it's important then to engage with the owner, either in writing or in a meeting, and try to reach some kind of consensus or agreement, to sort of enable that harmonious living, in complex living.
Okay, thank you, Gillian. Karine, in closing with you, I've got two interesting questions, and the common theme is here: circumstances have changed since the owners moved into the complex. So in the one case, a dog that was small and initially allowed has now grown big and is beyond the size parameter of what is allowed. And for another case, a young couple moved into a unit. They complied with the occupancy criteria. They've now had 3 children, and now they exceed the occupancy criteria. So what does one do where somebody buys a unit, lives in a complex completely in alignment with the conduct rules, but their circumstances have changed, often just because of life circumstances evolving and developing and maturing? What is the case there where, the conduct rules were initially complied with, but, evolutionary changes have now led to a conduct rule breach?
Yeah, Andrew, with regards to the pet, it's easy if the rules state that the pet must be a certain size, and I've seen that often. Then if the pet is no longer that size, then they are in breach of the rules, even if it's the same pet. So that one is clear. With regards to having a lot of children, you can't stop somebody from having children. So that has to be taken into consideration with regards to the rules, and maybe that owner can speak to the trustees and maybe get the rule changed. But if it's a council bylaw, then you will have a problem with council. So best will then be for that specific couple who have all these children to maybe look at a different accommodation that will accommodate all their children. It's a bit difficult, that one, but you have to take into consideration the rules at a specific time, and if they are in breach of the rules at that specific time. So yesterday you weren't in breach of the rules, today you are. We still have to act on that, and that basically is what I would like to say as my closing comment is: always be consistent. Apply the rules consistently to everybody at all stages. Doesn't matter who they are, if they're the chairperson, if they're an owner, if they're your friend, if they're not your friend, you always have to be consistent.
Okay, thank you. And I mean, the point I made at the client webinar we did on this topic is it is a responsibility of the trustees to enforce the conduct rules. And it becomes very problematic if the trustees shy away from enforcing the conduct rules and they do nothing about addressing breaches, and they allow issues to procrastinate. It gets much worse and much more complicated if it delays. It leads to temperatures and tempers, escalating, and that's not good at all. And, I would say the trustees are not meeting their role expectations and their fiduciary responsibilities if they are not actively and consistently applying and enforcing the conduct rules. So it's a really important point. And, again, I would say if the trustees are not doing that, it could be grounds for the owners to call a special general meeting with the 25% owners signing for a meeting to be convened and finding other trustees who would be more amenable to enforcing the conduct rules, or an executive managing agent. But this year alone, I've seen a couple of cases where the trustees have been apathetic, they've done very little, and sort of issues which could have been dealt with quickly and decisively and relatively simply have become major issues because they've escalated and they've snowballed and they've ended up in court. And there's been lots of sort of, animosity, which, could have been preempted if the trustees were proactive, met their role expectations, did what they were expected to do quickly at the outset, and move forward at that point. So just another important point. Just one technical question here, Karine. If at a general meeting, 5 trustee positions are agreed. What happens if only 4 trustees are willing to be nominated and elected? So theoretically, there's a vacancy of 1. Can the trustees, the 4 trustees, then co-opt an additional person into that 5th position after the AGM, or can a trustee only be elected at AGM into the 5th position?
No, Andrew, the trustees can co-opt. If the meeting decided 5 and there's only 4, then the trustees can fill that vacancy by co-opting somebody.
Okay, brilliant. All right, everybody. Today we had 53 questions, so that's our record, I think. So well done. Thank you very much for the questions. Hopefully they give practical, application to this topic, and hopefully they're common scenarios which will help as well. So thank you very much for participating. We appreciate your support and your attendance. I will send slides and the recording tomorrow to everyone that's asked. Again, we will send the insurance one after next Wednesday when we've got a full recording. And a reminder that the topic for next Tuesday at 3 o'clock is the topic of CSOS, when we'll go into more detail, and we might have a chance to add some other topics as well. So thank you, good afternoon, and we'll be in touch next Tuesday.